the importance of the contract. We've touched on the management agreement. The first question is really to answer the question you raised before, which is which contract? Who is in a contractual relationship with who? And it's important that you understand the different contracts that may apply to the management of your site and who can benefit from which one. The management agreement is between the client and the managing agent, not the leaseholders. And so if the client happens to be an RMC or an RTM co, then yes, the client and the leaseholders are essentially one and the same. But if the client isn't the leaseholders, so it's a third-party landlord or it's a management company written into the lease, then the leaseholders are not entitled to benefit from the terms of that management agreement. The lease is between the client and the leaseholders, so that's between whoever is the management party under the lease and the people living in the individual apartments. So I would argue, as leaseholders, the lease is much more important to you than the management agreement, because it's a contract that you can benefit from, it's a contract you can enforce, and it's a contract that sets out exactly what your rights and obligations are, and you can make sure that you have ways of making sure that, that those things are delivered to you. For right to manage companies and RMCs, there's another contract, which is the Memorandums and Articles of Association. That is between the company and its shareholders. Now, in such circumstances, leaseholders have two hats. They have their hat as a leaseholder and they have their hat as a shareholder. And under their leaseholder hat, they benefit from the Landlord and Tenant Acts and all the statutory protection that exists between landlords and tenants. With their shareholder hat on, then they're no longer benefiting from landlord and tenant legislation, but they're into company law and they're benefiting from their relationship with a company as a shareholder of that company. And then you have works orders and service contracts, which are between the client and the people actually doing work at your development. So again, if there's a service contract in place with a lift maintenance company that says they'll come out and visit your lift once every 3 months, again, you as a leaseholder can't benefit from that. It's not, you're not a party to that agreement. That is between the client, and so if the lift contractor doesn't turn up every 3 months as they're contracted to do, then it's the client who's got to do something about that, not you as leaseholders. So each of those different contracts that will affect the management of your business, the management of your development, sets out the rights and obligations of the parties, and only the parties that are the parties that are a party to each individual agreement can enforce it and benefit from it. So it's important for you to understand which of these documents actually you can benefit from, and to understand what rights and obligations that particular contract gives you. And I would argue that the most important document in respect of your relationship with the management of your property is the lease, and that's the one really you should try and know inside out. There can be quite impenetrable documents. They can be 40 pages long. For some reason, and you might be able to explain why, lawyers don't like commas. So one paragraph leads into another, and they can be quite difficult to interpret. But it's a very, very good idea to understand what your lease says, and to therefore know what you as a leaseholder are entitled to, what you as a leaseholder are obliged to pay for, and what you as a leaseholder aren't obliged to pay for. So you really should dig out your lease and make sure you know about what it says.
Sorry, Ben, can I pop in here? I think one of the important questions for us when we were putting the course together was to just flag up, for the sake of everybody who attends, that the contractual relationship between the resident management company or the right to manage company, where leaseholders are directors, is a very important relationship. And previously to the engage endorsed work that you and I did with other people, that wasn't clear. People didn't realise that was absolutely what mattered. And I think that's something we just want to flag up in terms of getting that contract right. And what seems strange to me as a leaseholder is that it doesn't often happen in any walk of life, that you will be contracting services to an individual or a company to come and be your managing agent, and they bring the contractual agreement with them that they're going to work to. Normally, you, as the person who's procuring the services, would provide the contract that they have to work towards. And I think this is one of the issues that we've been trying to grapple with and look at how residents can be clearer about what they want to see in the contract or the management agreement, and to write that into it and make sure that the contract that's signed benefits the leaseholders who are procuring the services of a managing agent.
I think you're absolutely right. It's contrary to normal consumer behaviour that the service provider comes along and goes, here's a contract, and potentially has the ability therefore to present you with a piece of paper that completely stitches you up. I think it's a matter of practicality that we as managing agents are dealing with management agreements on a regular basis, and your experience, Jerry, relates to a block of 420 apartments, and therefore I suggest you had the strength in numbers and size to put in place the procurement process that you put in place, and that a block of 12 apartments or a block of 24 apartments or a block of 36 apartments probably wouldn't go through the process you went through, simply because of the practicalities and the cost and everything else. And therefore you probably, again, when appointing a managing agent, wouldn't want to go to a lawyer and spend however much you'd have to spend to get your own management agreement drawn up. So it's a matter of practicality that therefore when I'm approaching a block of 36 apartments and they say, we want to use you please, I say, all right, well here's a contract you can sign to appoint us. It's the wrong way around, but it's just easier for that block of 36 apartments to read my agreement. And we would always say to them, please read it, and if there's anything you're uncomfortable with, come back to us and talk to us, and then we'd have a dialogue with them. I also admit that the vast majority of schemes don't. They probably don't read it, or if they do read it, they certainly don't come back to us and ask for things to be changed, and they just sign on the bottom line and away we go. And as with, I think, the final line on here is the contract is the legal agreement that will be relied on when things go wrong. And you touched on that with your management agreement, and you put in place lots of time and effort to make sure that it gave you all the get-outs you needed, and it gave you the right level of service agreement with the managing agent. And then what you find is, while everything is going swimmingly, it goes in the bottom drawer and no one ever pulls it out again. Until you get to a situation where you want to part company, and then all of a sudden the management agreement will become very important again, and everyone will be reading it and going, oh, how do we terminate these people's services? So it's very important that it's right, and it is hugely important that it sets out the right arrangements and that you understand precisely what it is that you're getting from your managing agent in return for the management fees you pay. And then in reality, if you pick the right managing agent, you never read it again. Yeah. I think, as in terms of RTM companies and RMCs, and I don't know what the mix is in the room of people who are in control of the management of their blocks, if you like, by being an RMC or an RTM, or whether people are essentially a passenger in relation to the management of their block, because it's either instructed by your freeholder or you've got a management company written in. But where you are an RTM or an RMC, the management agreement is all important, and it is your document, and it will and it should set out how often your managing agent visits the site, how often your managing agent provides you with financial information, how quickly after the year end they have to get your service charge accounts to you, whether or not you have to sign off the budget before it gets issued. All of those practical arrangements which make a big, big difference to the way in which your properties are being managed.
I think just a final thing, one of the things important is that if you're a residents association, you actually have no right at all to comment upon things that you'd like to have some control over, because you're not a party to the contract. And that's something which is quite difficult in the vast majority of developments in the city to understand, because you're paying for it, but you're not a party to the contract between the management company, which can be a professional company, and the managing agent that they appoint. And sometimes, of course, it's the same person, same company. The management company is also managing the development directly. And I think one of the issues we've had is where residents' associations completely misunderstand the relationship and start telling the contractors on site what they can and can't do, when in fact they've no right whatsoever, and they achieve nothing except a lot of frustration, when they need not to tell the contractor on site what to do, but to go to the people who are parties to the contract in the first place and get them to change the behaviour of contractors working.
I mean, residents' associations, they have a right to be consulted about the appointment of a managing agent, but they don't have a right to influence the terms of the management agreement. And I think it is what is quite unique about leasehold management is the concept that the person who employs the agent is completely distinct from the people that pay the agent. And that is probably goes to the crux of all the dissatisfaction that can possibly exist within leasehold management, is that the people who instruct and tell the agent what to do are completely different from the people that pay them. It is what it is. I can't stand here and change that for you.